The information in this video is for educational purposes only and is not legal advice. I am Mr. Burhan, and US Visa News Hub is not a law firm and does not provide legal representation. Please consult a qualified immigration attorney for guidance specific to your situation, and always verify the latest updates directly at uscis.gov and travel.state.gov. Priya had been in the United States for 11 years. She came from India on a student visa, earned her nursing degree, found a job at a hospital in New Jersey, paid her taxes every single year, and followed every rule the system ever asked of her. She renewed her H-1B 3 times. She waded through years of backlog with a patience that only people who have lived through this system can truly understand. Then, last year, her priority date finally became current. She filed her Form I-485, her green card application, right here inside the United States, just like the law allowed. Her attorney told her the paperwork was clean, her record was spotless, and all she had to do was wait. For the first time in 11 years, Priya allowed herself to believe that the end of the waiting was finally in sight. Then, on May 22, 2026, she opened her phone and read something that made her stomach drop. USCIS had just published Policy Memorandum PM-602-0199, a document that officially described getting a green card from inside the United States as an extraordinary form of relief and an act of administrative grace. Not a right, not a standard process, a favor. Priya called her attorney in a panic, and her attorney told her the truth. The rules had changed overnight. If you are Priya right now, if you have a pending I-485, if you are on an H-1B waiting for your green card, if you did everything right and still feel like the ground just shifted beneath your feet, then this video is the most important thing you will watch today. My name is Mr. Burhan, and welcome to US Visa News Hub. Stay with me because what happened next and what you need to do right now could make all the difference for your case. To understand why Priya panicked and why hundreds of thousands of people across the United States panicked with her, you need to understand what this memo actually said, and more importantly, what it actually means. On May 22, 2026, USCIS published Policy Memorandum PM-602-0199. The official title of that document sent shockwaves through the entire immigration community the moment it was released. The title was, "Adjustment of Status is a Matter of Discretion and Administrative Grace, and an Extraordinary Relief that Permits Applicants to Dispense with the Ordinary Consular Visa Process." Read that title again slowly. Adjustment of status, the process of getting your green card from inside the United States, is now being officially described by the U.S. government as extraordinary relief and administrative grace. The USCIS director accompanied the memo with a public statement that made the government's position crystal clear. He said that non-immigrants, like students, temporary workers, or people on tourist visas, come to the United States for a short time and for a specific purpose. The system is designed for them to leave when their visit is over. Their visit should not function as the first step in the green card process. He then added that from now on, an alien who is in the United States temporarily and wants a green card must return to their home country to apply, except in extraordinary circumstances. That is the government's own statement. That is what USCIS published on its official website. And the word extraordinary appeared again and again in every official document released alongside this memo. Immigration attorneys across the country read it and immediately sounded the alarm. Their phones did not stop ringing for 3 days. Now, before panic sets in completely, let us be very clear about what this memo does and does not change, because both sides of that answer matter enormously for your specific situation. What the memo does not change is the actual law passed by Congress. USCIS cannot repeal an act of Congress with a policy memo. The Immigration and Nationality Act Section 245A still exists. It still says that the Secretary of Homeland Security may adjust the status of an eligible applicant who was inspected and admitted or paroled into the United States. The legal right to file Form I-485 still exists today. USCIS has not announced that it will stop accepting new I-485 applications. If you are eligible to file, you can still file. What the memo does change, and this is the part that matters most for every single person watching this right now, is how USCIS officers must think when they review and decide your I-485 application. Before this memo, if you met all the eligibility requirements, the right status, priority date current, clean record, approved I-140, approval was essentially expected. The officer's job was mostly to verify that you qualified. Now, the officer's job is explicitly to ask a very different and far more serious question. Does this person deserve this extraordinary form of relief, given that they could have applied through a consulate abroad? That is a fundamentally different question, and the answer to that question, under this new policy, could go against you even if your paperwork is perfect and your record is spotless. That is the change. Not whether you can file, but whether filing will lead to approval. Then something happened that most people missed entirely. On June 1, 2026, just 10 days after the original memo, USCIS said something new. The American Immigration Council updated its analysis on June 1st to reflect new statements made directly by USCIS. The agency clarified that the memo will be implemented on a case-by-case basis, explicitly stating that many immigrants will still be able to remain in the United States while applying for green cards. The Department of Homeland Security spokesperson provided additional context, saying that the memo is intended primarily to remind officers of existing policy rather than to introduce new eligibility restrictions. The DHS spokesperson specifically said that the agency's focus is on people who overstayed visas or came from countries whose citizens are heavy users of public assistance. These are not casual statements. These are on-the-record clarifications from the government agency that wrote and published the original memo. They represent a significant narrowing of how the policy will actually be applied in practice, even though the memo's legal language has not been changed. That distinction between what a policy memo says and how the agency says it will be applied is critically important, and it is something that most media coverage has failed to explain clearly. The sky did not fall on May 22nd. But the ground beneath millions of people's feet did shift in a real and meaningful way, and understanding exactly how it shifted is what this video is about. This video is for informational purposes only. Please consult a qualified immigration attorney for advice specific to your situation. The June 1st clarification changed the picture significantly, but it did not erase risk entirely, and which side of the line you fall on depends entirely on the specific facts of your case. Let us go through the groups one by one. The first group, and the most protected, is spouses of U.S. citizens. Immigration attorneys at Boundless, one of the most respected immigration analysis firms in the country, have stated clearly that for spouses of U.S. citizens with no arrest record and no prior immigration violations who can demonstrate positive factors for remaining in the United States, the favorable exercise of USCIS discretion is expected to continue just as it always has. This is enormous news for the hundreds of thousands of marriage-based adjustment applicants currently in the system. For this group, the May 22nd memo may ultimately change very little in practice. The second group is H-1B workers and other dual-intent visa holders. The memo explicitly acknowledges that non-immigrant visa categories that allow dual intent, meaning you can hold a temporary visa while also pursuing a green card, are recognized in law. But the challenge is that dual intent status alone is not sufficient to guarantee adjustment approval. It is a recognized positive factor, but workers need to affirmatively present what the memo calls unusual or outstanding equities, strong positive factors that demonstrate concretely why their specific case deserves adjustment inside the United States. The third group is immediate relatives of U.S. citizens, spouses, children under 21, and parents. These applicants have the strongest statutory protections of any adjustment category, and the case-by-case framework is least likely to disrupt cases in this group that have strong positive equities and clean immigration histories. The fourth group, and this is where genuine risk lives, is anyone with complicating factors in their immigration history. If you ever overstayed a visa, even briefly, if you ever worked without full authorization, even briefly, if there is any period where your status was unclear, if you entered on parole, if there is any history of misrepresentation or inconsistency in previous applications, any of these factors creates a genuine risk under the new discretionary framework. And here is the most troubling element of all. USCIS has said explicitly that choosing to remain in the United States and file for adjustment of status instead of departing for consular processing can itself count as a negative factor. Think about that. The simple act of filing inside the United States, which the law still permits, can now be used against you by the very officer deciding your case. Under the new memo, when a USCIS officer reviews your I-485 application, they are now explicitly instructed to conduct what the memo calls a totality of the circumstances analysis. That means they will look at everything about your case holistically and weigh positive and negative factors against each other before deciding whether to approve your application. On the negative side, the factors that can weigh against you include any violation of your non-immigrant status or parole conditions, any period of unauthorized employment, any misrepresentation or false testimony in any previous immigration proceeding, any failure to depart when your authorized stay ended, any criminal history, and the simple fact that consular processing was available to you and you chose to remain in the United States and file for adjustment instead. On the positive side, factors that can weigh in your favor include long periods of continuous lawful status in the United States, a clean immigration history with no violations or misrepresentations, strong ties to the country such as U.S. citizen or permanent resident family members, stable long-term employment, property ownership, or deep community roots, evidence of professional contributions or specialized skills, and humanitarian considerations such as medical needs or dependent family members who would face genuine hardship if the applicant had to leave for consular processing. The critical practical implication of all of this is that if you have an I-485 interview coming up, or if you expect your case to be adjudicated soon, you and your attorney need to proactively build and present the affirmative case for why your specific situation warrants adjustment of status inside the United States. You cannot simply show up with qualifying documents and assume that meeting the eligibility requirements is enough. You need to tell your story. You need to present your equities. You need to make the officer understand, clearly and with full documentation, why approving your case inside the United States is not just legally permissible, but genuinely and specifically warranted by the facts of your individual situation. There is one more critically important aspect of this new policy framework that almost no one is discussing publicly right now. The most likely near-term consequence of this new policy, based on the analysis of immigration attorneys who are already seeing the early effects at USCIS offices, is not mass denials. It is not a wave of people being forced to leave the country. The most likely near-term consequence is a significant and immediate surge in requests for evidence and notices of intent to deny. Immigration attorneys at multiple major firms have said publicly that they are already seeing additional questioning at adjustment of status interviews that did not exist before May 22nd. Officers who previously reviewed applications primarily to verify eligibility are now also conducting a more explicit discretionary analysis, documenting positive and negative factors even in cases where they ultimately approve the application. That documentation process takes time. It generates more questions. It produces more RFEs. And that means processing times across the entire adjustment of status system are going to slow down. Not because USCIS is denying more cases necessarily, but because the administrative burden of the new discretionary analysis is adding time and paperwork to every single file that goes through the system. If you have a pending I-485 and you have been waiting and wondering why nothing seems to be moving, this is part of the answer. And if you receive an RFE in the coming weeks or months, do not panic. An RFE is not a denial. It is USCIS asking you to provide more information so the officer can complete their discretionary analysis. Your response to that RFE needs to be comprehensive, well-documented, and specifically addressed to the positive factors in your case. One of the most urgent questions people are asking right now is what happens to cases that are already in the system at various stages. For cases that were fully approved and the green card was already issued before May 22, 2026, those cases are completely unaffected. An approved green card is an approved green card, and the memo does not apply retroactively to completed cases. For cases with interviews already scheduled, the situation is more concerning. There is nothing in the memo that prevents an officer from applying the new discretionary framework at an interview that was scheduled before the memo was issued. If your interview is coming up in the next few weeks, this is exactly the conversation you need to have with your attorney before you walk into that room. For cases with a pending request for evidence, The response you submit should now be prepared with this new discretionary framework in mind. Your response is not just about satisfying the technical requirements of the RFE anymore. It is also an opportunity to present your positive equities and make the affirmative case for why your adjustment is warranted in your specific circumstances. For cases that are pending without any current action, these cases will be adjudicated under the new standard whenever a USCIS officer gets to them. There is no protection for having filed before the memo was issued. That is the most significant and most difficult reality of this new policy for people who have been waiting patiently and lawfully for months or years. Now let us talk about what you need to do, because the only productive response to this news is not panic, it is preparation. The first and most important thing you must do right now if you have a pending I-485 application is contact your immigration attorney immediately. If you do not have one, find one now. This is not the time to manage this process alone. Many immigration attorneys are already reaching out to their I-485 clients proactively in response to this memo, and if yours has not contacted you yet, you should contact them today. The second thing is to gather and organize every document that demonstrates your positive equities in the United States. Employment records, tax returns for every year you have been here, evidence of property ownership or long-term lease agreements, evidence of U.S. citizen or permanent resident family members and their dependency on you, any letters from employers or community organizations who can speak to your contributions and your ties. The stronger and more complete this record is, the stronger your case will be under the new framework. The third thing is to be completely honest with your attorney about anything in your immigration history that could be a negative factor. Overstays, periods of unclear status, any prior applications with inconsistencies, any criminal history. Your attorney cannot help you effectively if they do not have the complete picture, and in the current environment, surprises at a USCIS interview can be catastrophic. The fourth thing is to check the official USCIS website directly at uscis.gov and follow any updates to Policy Memorandum PM-602-0199, because additional category-specific guidance is expected. The situation is still evolving, and the official government website is always the most reliable source of updated information. The fifth thing, for anyone who has not yet filed their I-485 but is planning to, is to have a detailed conversation with an experienced immigration attorney before filing. Because the strategic calculus around whether to file inside the U.S. or pursue consular processing has become significantly more complex, and only an attorney who knows your full situation can advise you correctly. Let us go back to Priya, the healthcare worker from India whose story we started with. She called her attorney on May 22nd in a panic. Her attorney reviewed her case carefully. 11 years of continuous lawful status, 3 H-1B renewals, all filed on time, a clean criminal record, no visa violations, a U.S. citizen spouse, a child born in New Jersey, a career at a hospital that depends on her, and has supported 3 rounds of sponsorship paperwork. Her attorney told her something after the June 1st clarification that immigration attorneys across the country are now telling clients like her. The sky did not fall. The memo changed something real, but what it changed for Priya, given the strength of her case, is not the likely outcome. It is the amount of work required to document and present that outcome clearly to the officer who will decide it. Priya and her attorney spent 2 hours building a comprehensive record of her 11 years in the United States, employment records, tax returns, her child's birth certificate, her marriage certificate, letters from her employer, community involvement documentation. Not because she was in danger of losing, but because in 2026, showing up with qualifying paperwork is no longer enough. You have to tell your story. And Priya's story, told clearly and completely, is one that any reasonable USCIS officer should be able to approve with full confidence. That is what case-by-case means when the case is a strong one. And that is the outcome that the June 1st clarification makes possible for people who built their lives here the right way. The situation is still developing. Category-specific guidance from USCIS is expected. Court challenges are being prepared. More updates will come. But the picture today is meaningfully clearer and meaningfully less alarming than it was on May 22nd. The most important thing you can do right now is get informed, get prepared, and get qualified legal support for your specific situation. Because in 2026, the difference between a smooth path to a green card and a complicated one often comes down not to what is in your file, but to whether you understand what is in your file and how to present it. Do not let fear make your decisions. Let knowledge make them. And knowledge is exactly what we are here to give you. US Visa News Hub provides immigration news and general information only. Always consult a qualified immigration attorney before making any decisions about your case. Everything discussed is based on USCIS Policy Memorandum PM-602-0199, USCIS.gov official statements, and the American Immigration Council June 1, 2026 update. Official guidance, available at uscis.gov and travel.state.gov. If this video helped you, please like it, share it with every immigrant you know who has a pending I-485, and subscribe to US Visa News Hub so you never miss a critical update. The moment USCIS releases category-specific guidance on this memo, we will cover it immediately. My name is Mr. Burhan. Stay informed, stay prepared, and we will see you in the next video.